Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. My name is Alicia Downey, and the title of today's episode is What's at Stake Here? Issues with the State Antitrust Enforcement Venue Act. States can file complaints under either federal or state antitrust law, but they're subject to the Judicial Panel on Multi-District Litigation Proceedings, which allow defendants to request consolidation of a case with similar antitrust lawsuits filed by other states or private plaintiffs in multiple jurisdictions. Many state attorneys general have argued that this involuntary centralization of state actions violates their sovereignty and potentially benefits defendants unfairly. Joining me today is my co-host, Anora Wang. Hi, Anora.
Hi, Alicia.
Anora, would you like to introduce our guest?
Yeah, for sure. Our guest, Yee Wah Chin, is counsel at Ingram Yuzek in New York, engaging in antitrust counseling and litigation, particularly on mergers and at the IP antitrust interface. Previously, Yee Wah has been a senior counsel and partner with AmLaw 100 law firms and assistant general counsel for antitrust at a Fortune 100 company. Yee Wah holds multiple leadership roles in the antitrust bar, including being the chair of the Antitrust and Trade Regulation Committee of the New York City Bar Association, vice chair of the ABA International Law Section, and former vice chair of the Antitrust Law Section International Committee. But I have worked with Yee Wah on several of the bar-related comments projects, so I'm very lucky and happy to have her on our Curious Amalgam finally.
Well, so am I. Welcome to the program, Yee Wah.
Well, hi there. Thanks very much, Alicia and Nora, for inviting me and for the kind welcome.
Pleasure is all ours. Alicia has introduced the topic. I may as well provide a little more background here, and I hope you may joining me and indulging us for not understanding the subject that well. So what is the State Antitrust Enforcement Venue Act? And is this currently being considered and has not been passed?
Well, it is an act to adjust the system under the Judicial Panel on Multi-District Litigation, and so far, it has not passed. It has gotten through the Senate, and it's still being considered in the House. So therefore, it is still not yet ready to be signed. It seeks to make one change in the current law regarding multi-district litigation.
So we're speaking in an environment where people are thinking of reforms into the antitrust laws in the United States. So again, connecting to the big picture here. So the State Antitrust Enforcement Venue Act, as it's being proposed and considered, is among a slew of other bills being proposed and considered. Is that right?
Correct. There's depending on how you count them, there's easily a dozen or so bills around Congress, some of which duplicate and overlap each other, and some of them are a much bigger picture in the sense that they try to really change some of the substantive standards of antitrust. Many of them are clearly intended in the current environment to try to address what are considered to be concerns with the big tech companies. But this one is a very focused bill, focused on a procedural issue relating to how the federal judiciary handles many, many lawsuits covering exactly or just about exactly the same conduct with a common set of defendants. Congress in 1968 enacted the JPML Act. And that created the Judicial Panel on Multi-District Litigation, which is a panel of 7 federal judges appointed by the Chief Justice from different districts that will hear and decide on motions to consolidate and coordinate the pretrial proceedings of lawsuits with common facts or issues of facts and law in the interest of efficient adjudication and for the convenience of the parties and justice. So that's been the system that's been set up since the late 1960s, and it has really managed hundreds of thousands now of cases that's been organized into these MDL cases.
Right,
now, the
right.
one exception, if I may, to the system where the JPML can consolidate cases is criminal cases and injunction cases brought by the U.S. Department of Justice. That's the one exception to being subject to being transferred and consolidated with a whole bunch of other cases for basically oversight by one judge. And that is really the purpose of this bill, the State Antitrust Enforcement Venue Act, which is to add to the states to this one exception to being transferred into and being put together with a whole bunch of other lawsuits under the JPML system.
So, Yee Wah, before we go any further, so what has led us to the bill, and what has prompted the drafters of the bill to make their proposal?
Some folks will say, and it seems supported by the chronology, is that there's been many, many lawsuits against Google, and one group of them had been transferred to New York, and the state AG of Texas, along with several other state AGs, had brought a lawsuit in Texas federal court on similar subject matter. And unsurprisingly, Google made a motion to the JPML to have this case consolidated. And Google had actually sought to move it to California, where, of course, Google is at home. The state AGs, of course, wanted to have it stay in Texas. The JPML decided to move it and consolidate with the existing actions that they had already consolidated in New York. And that did not go down well with the states. And so lo and behold, you saw shortly introduced into Congress this bill.
I understand that, both the federal and the state level enforcers of the antitrust laws have voiced some support for this bill, including 32 AGs. There might be more, but 32 as I have counted. And then the DOJ and the FTC, they have all the current leadership. They have all in written materials expressed some support. For instance, DOJ has a statement essentially saying they think the bill would harmonize the treatment of venue for antitrust cases filed by the state attorneys general with those filed by the federal agencies. And the FTC's current chair, Khan, has said something similar, which essentially it would be better to enable state AGs to maintain antitrust cases in venue that they select. So obviously these are pointing to the arguments for the bill, right? Just so that we have a more wholesome understanding. What are some other arguments that have been made for this bill?
One argument has been would be strengthening federalism and states' rights, because it will put the states on an equal level with the federal government in their prosecution and enforcement of the antitrust laws, so that it really is a strengthening of federalism. And that, I believe, is partly the reason why this bill has bipartisan support.
And there are some resources argument, right? Are there arguments being made that if the state AGs can select the venue that they want, and they would be better to prioritize the resources that they can devote to the litigation? How is that argument being played out?
The argument there, as I understand it, Anora, is that when the state's cases are not wrapped in with all the other cases in one JPML litigation, they can focus on things that are specific to the interests of their citizens, which may not be the same as the interest of private plaintiffs in their lawsuits. And so therefore they can really proceed more efficiently and effectively to get a remedy for their citizens faster than if they were to trundle and be wrapped around this whole big mass of lawsuits being managed. And they raise as examples that, when the Google case that they brought got transferred to New York, they were put on hold while they were still trying to wait for all the other private plaintiffs to do their thing. Whereas if they were on their own, they could have gone out a lot faster doing their stuff. And in fact, they have the advantage of being able to conduct a pre-complaint investigation, which private plaintiffs don't have as much the ability to do. So therefore, they were really chugging along, doing fine, thank you. And now they really slow down. And that's certainly part of their reasoning there too, or at least their rationale for supporting this bill.
One other argument, I guess, that has been made for the bill is that it would give the state AGs more control in picking the cases, and also in the case that they did pick, and they would have more control over managing it, right? I guess there are some merits to that. Do you think so?
Well, it's unclear to me that it gives them more control over their choice of cases, because they are the ones who always can choose which complaint to file to begin with.
I see.
But in terms of the management of the case, once it gets into court, yes, when you're part of a whole several hundred or several dozen other plaintiffs' cases running together, and you've got to coordinate with other lawyers and not just the several dozen AGs that sometimes may be involved in a case, certainly you've got less control by the very nature of just having that coordinated activity. But in terms of choice of the case, that's up to them as to, what case they were going to bring.
I thought it has something to do with, if you are bringing a case that's more focused on the constituency that you have, and then it's very much brought under the state laws, and then you probably would have somewhat more focused or pronounced enforcement of the state laws. That's something people see merits in. I guess that's the argument.
If you're really concerned about your state law ancillary jurisdiction claims, then maybe those are claims being state law claims should be brought in state court. But if we're talking federal law claims, that's not much of an argument as far as I could see, in terms of, you've got a whole bunch of similar federal law claims, and you've been put together with a whole bunch of other similar federal law claims.
Right. And then let's turn to the arguments against the bill, right? So we talked about the cost issue a little bit. So what's the flip side of the things?
That, in fact, this really would be diluting much of the benefits of the JPMO system, because the JPMO system was really put together not just for the convenience of the parties and the efficient adjudication of cases and administration of justice, but it's really to help the federal judiciary system to manage its own docket in a very much more efficient way. Because yes, until the act passed, what was happening was really a whole series of ad hoc arrangements to try to manage things, so that for each separate case or each group of cases that seemed to be similar, what was happening is that you would have individual judges over however many districts basically coordinating with each other. So you've basically then tied up a whole group of federal judges on each bunch of cases to manage the pretrial issues that are running common amongst all of these cases, and to try to coordinate to save judicial resources and to avoid repetitive or duplicative adjudication of similar kinds of discovery issues or pretrial motions. And now the current system is that instead of having several federal judges tied up getting into conference calls or whatever to try to coordinate on common issues that they are facing in the sets of cases, that the overlapping cases that they see in their docket, you've got one judge managing all of this as almost like a traffic cop in a way, before sending the cases back to the originating district for trial.
I just want to add one more data point. I think the Congressional Budget Office has done a study of some sort on this bill, and they anticipate that although some cases affected by the bill might be resolved more quickly if they remain in their original venues, in many cases the total workload for judicial staff members would increase if related suits were not consolidated, right? And then CBO's estimate also include that on balance, administrative costs for the judiciary would increase by a total of $1 million over the 2022 through 2026 period. So obviously that's estimates and by the CBO that and limited data points they can get, right, as well. But that I guess connects to my point, right? There is cost to defendants. There is also cost to the judicial system, right? So I think that's your point, right?
Correct.
And what about the cost to the AGs, right? I thought, right, consolidating, if the AGs can join forces, it's generally a good idea for them to sort of pick and choose. They can some states, if they are not that devoted to a case but they still want to join, they can join, right? Now if it's a state is bearing the whole weight, that's probably more costly to the state.
That's a very good point, Anora, that in fact from the efficiency and economy dimension, it's not really in favor of the states at all, in the sense that they will really need to do all the work themselves, as opposed to basically leveraging from some of the activities and work of the private case counsels. But it is also true that in the current situation, in many cases, if it's only the states by themselves, it's also true that even there, some of the state AGs are already getting the benefit of being, if you want to call it, a tag-along. And there are usually, the way those state AGs work is that they do have one or two of the state AGs being lead, and the others are there, one might say, for the ride and getting the benefit of the work as it is. So from that perspective, one can say that inherently the state AGs, by the way they work on these cases, they already do have some efficiencies that they've created for themselves, but they won't have the extra efficiencies of being able to also take advantage of the work of the private plaintiff lawyers there.
Right.
But it seems clear that for some of the AGs, they're doing a different calculus too, that they would prefer what they see is more control over their case and how they can prosecute the case and how they can present the case to the public. And perhaps more than private plaintiffs' lawyers, the state AGs are much more conscious of the public perception or the PR aspects of them bringing lawsuits. And if they're just one of many plaintiffs, as opposed to being this is the state AG's case, that has a very different public profile, if one may call it that.
Right. So if it is passed and is currently drafted, so the state AGs would have a choice of having their case to consolidate or not, or how is that working? Does it just give the AGs a more option, or the default would be that case is not being consolidated?
Well, basically is simply that they cannot be subject to a motion, which is the way the JPMO system now works. One of the parties, often a defendant, but sometimes also the plaintiffs too, they could just bring a motion before the judicial panel to say we would like to have this case transferred and become part of this multi-district litigation if there's
Right.
already a multi-district litigation ongoing. Or if there hasn't been, one of the parties would make a motion to say we are one case and we understand there are several other cases that are really similar to ours, and we move the judicial panel to consolidate and to transfer them all to one district so that they can all be consolidated and coordinated for pretrial proceedings. So this amendment has literally only one sentence to it. Literally, all it says is Section 1407 of Title 28 of the United States Code is amended. One, in subsection G, by inserting, quote, or a state, close quote, after, quote, United States, close quote, and two, by striking subsection H. And that's it. That's all it says, literally. And so therefore, all it does is really say that you cannot make a motion to try to move a case brought by the state AGs in a similar fashion as you cannot make a motion to move a case, transfer a case brought by the United States. What might not be apparent by this very simple amendment is that the subsection G relates to only cases that are brought by the United States for criminal and injunctive relief. It does not, and it specifically, if you look at the entire subsection G, it specifically does not exempt the United States from transfer under the JPML system, the cases that the U.S. brings for damages.
And one last argument, I thought I would bring that up. I think it's important, and maybe we can talk about it quickly, which is kind of obvious, right? If you have not consolidated cases and then you have different judges or benches, and then there would be uncertainty on having different results, right? How should that be addressed?
If I may, Anora, I'll just finish off one little point in terms of that exemption. It is that the states generally, they could bring cases for injunctive relief and they could bring cases, obviously, for damages. Whereas the federal government has injunctive relief, damages, and criminal sanctions. The exemption that the federal government has is only for criminal prosecutions and for injunctions. They don't get the exemptions for damages. So therefore, for the states to get the similar exemption, it would be actually getting an exemption from all kinds of cases, including the damages cases, because this amendment does not specifically really make it parallel to the federal exemption. So in fact, the states will be getting more than the federal government has in terms of being exempt from the JPML system. So therefore, the argument of this putting the states on an equal footing for the federal government is, at least as I read the bill, is not quite accurate. So, okay, then your point, Anora, in terms of inconsistent rulings, that certainly is a possibility, and that's part of the concerns that the JPML system was trying to address, that you don't have conflicting rulings, which may result in one party or another possibly being whipsawed because in one district they need to do something and in another district they may need to do something that's not quite consistent, or in fact perhaps inconsistent, and they'll be whipsawed or between a rock and a hard place, or perhaps requiring folks to reach up to the appellate courts to try to harmonize it if possible, if they can't even have an issue that's subject to appellate review at that stage, which may not be the case because the JPML system itself, the MDL system itself, is really intended to handle pretrial proceedings. Many of those are really not subject to or not reviewed that much at the appellate level. But regardless, that clearly does add to a whole layer of uncertainty and and possibly extra burden on the parties and on the judiciary in terms of needing to go through possibly more proceedings at whatever level, be it at the district court level or at the appellate level, to see if they could iron out any conflicts there.
I think that's all very helpful and insightful. Your point about whether the states are actually as advertised being put on equal footing, but actually getting more favorable treatment under the law is an important one. Because if you're just talking about costs, it's really hard to discuss on an abstract level, right? And it could vary from case to case, and it really parties' behavior can change, right? So that's very helpful. I guess just one more substantive questions from me, which is what other predictions that you would have on the development of this bill and maybe some other bills that's being proposed?
The prospects for this bill is that right now it may actually pass in before the end of the current Congress, and it is one of the bills that are more likely to pass than the others, in part because it is so lower profile and because numerically it will affect a small number of cases, because after all, the state AGs only bring a certain number of cases every year. So from that perspective, it may pass, whereas many of the higher profile ones are still, as we can see in the headlines, being fought over pretty fiercely.
Yee Wah, thank you so much for that wonderful outline of the issues. So I gather then you think the bill is likely to pass. Is that fair to say?
I think that it still has a significant chance, a higher chance than just about all the other bills that are out there, with the possible exception of the bills that are increasing the budget for the federal antitrust agencies and adding to their headcount. And those bills are very likely to pass also. But yes, this one is one of the ones that will have the highest chances of passing.
Okay.
Nothing is 100% in life, but I would put this at, let's say, above 85%.
Oh, okay. Well, we'll certainly find out, I guess, sooner rather than later. What we'd like to do now at the end of the show is what we do with every guest, which is to find out a little bit more about them as people. So one of the questions we ask is, can you tell us something interesting about yourself that we wouldn't know if we only knew you professionally?
One of the things that at least has been very interesting to me is life is very serendipitous, and I found myself spending much of the last 10 years as an expat. And that has certainly given me an added perspective on things in general, including the practice of law and antitrust law, because it gave me a closer insight to how folks may view antitrust challenges in other parts of the world. So I found myself spending a year in Wellington, New Zealand, as a visitor at the law school of the Victoria University of Wellington. I found myself with a semester in Japan, in Tsukuba, a city about 40 minutes outside of Tokyo. And I found myself 4 years in Seoul, where I had the opportunity to teach as an adjunct at the law schools of Yonsei University and Korea University, and really got to meet and make friends with academics and practitioners, and really get a sense of where they see antitrust law and practice in their countries and in their part of the world. So that was very interesting to me, and certainly serendipitous, since it wasn't something that I would have thought would be something I would be doing when I first started out in practice.
Well, that does sound very interesting to me, too. I'm frankly a little jealous. And now for the final segment, this is probably the game show sequence. We're going to ask you a surprise question that you haven't heard before. It's a game we call the Curious Hat.
And now it's time for the Curious Hat.
I'm going to let Anora choose the surprise question.
Okay, let me pick question 8. How would you spend a perfect weekend?
A perfect weekend would be the one that I could spend sort of reading and having a nice meal out. I'm very good for eating out.
Well, that sounds pretty nice
Sounds
too.
very nice.
Well,
Yes.
thank you so much for being our guest today. As I say,
pleasure.
we'll await the outcome and see whether your prediction was true. To everybody else listening, join us next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.